The committee find the allegation to have been substantiated, and that the respondent has been guilty of conduct unbefitting a solicitor. And the committee order that the name of the respondent, David Main, of the Boltons, London, solicitor, be struck off the roll of solicitors of the Supreme Court, and that he do pay to the applicant's costs of and incidental to this application and inquiry.
Look, just tell him that Mr. Main will call back as soon as he drives. David, there's been hundreds of messages for you. Lord Arkwright's particularly insisted
Come in.
we have...
What's the panic?
Well, everybody expected an acquittal. They can't believe that you're struck off, and they're worried about you, but about their job.
I send in the heads of department. I'll talk to them.
Right.
David, I've just heard the result. I'm extremely sorry.
Don't be, not yet.
Now, it's bad enough in the Leeds office, but at least Margaret and I survive as partners there. But here in London, you're the sole partner. What will happen?
Just let me say a few words, then we'll talk. Come in, ladies and gentlemen. Well, you know the story. I tried and failed to put an end to the activities of the man responsible for the deaths of my wife and son. A man who employs drunken lorry drivers, who bribes policemen and scientists to suppress and destroy evidence. Well, because I failed, the Law Society decided to try and prove that my methods amounted to professional misconduct. They failed.
I should remind you, Mr. Main, that the disciplinary committee found you guilty.
I have no intention of being put out of business by our...
You have no choice.
Henry, will you please let me finish?
Look, your staff want to know if they still have their jobs or not.
Of course, you're right. I'm sorry. Don't worry about your jobs. I've given notice of appeal, and legally, it's the strongest case this office has ever handled. The order striking me off is now suspended, pending appeal. Well, thank you for your concern, your support. And shall we now get back to our client's problems? That's what we're here for.
What's the panic, Inspector?
Every time I asked him a question, he yelled for David Main or Walter Clegg. Main's not answering his phone, so I sent for you.
And I'm out of business.
Look, I have 4 unsolved murders and 100 anonymous burglaries. You want me to worry about professional etiquette?
I'm serving a suspended sentence for forgery and theft. I'm banned working for David Main.
Come in. Look, your name's Walter Clegg. He wants to see you. So, okay, you're a friend of the family.
Fair enough.
Yeah.
What's the charge?
Roy Wilson Gibbard broke into number 10 Hilton Drive, stole 3,000 quid's worth of jewellery and put the owner of the house, Mrs. Elizabeth Martin, in hospital.
You can prove that?
It's Gibbard's modus operandi.
All you've got against him is police Latin, his method of operation.
When you were a copper, you put him away a couple of times yourself. His methods are as good as a fingerprint.
He usually has an alibi.
He got careless.
Not friend Gibbard.
They all do. Look, he's been lucky 3 years, thieving all that time without getting nicked and making a good living. They all get careless sooner or later. Do him a favour. Tell him his only hope is to cop it all, plead guilty. I'll put in a good word with the judge.
You're bending the rules.
I hate violence. The rest, well, it's a job for them and for us. But violence is something else. Well, Mrs. Martin's in a bad way. She could die. Gibbard's going away for this for a long time.
What are you using for evidence?
Don't knock the Latin. Modus operandi. That's what'll get him this time. Look, he's done it before a dozen times. Exactly the same pattern.
You can't use record to prove he's done it again.
I've checked. Legally, I can. And I will.
You had no business seeing him.
I was straight with Detective Inspector Shannon. He's not complaining. Gibbard wants to pay you $2,500 plus expenses.
After you twisted his arm, what's he done?
Same again. Only this time he just could be innocent.
That sounds like a fast value judgment.
Yes, I know when a job's not straight up. Now, Shannon's a good copper, but he's overworked. They all are. In crimes like burglary, getting evidence is impossible. Shannon knows this is how Gibbard makes a living. It isn't the burglary that bothers him. Violence. That's what makes him bend the rules.
All right. But Margaret handled his last case. She can handle this one. I've got my hands full with my appeal.
Now, he wants Hugh Neville, QC.
He's one of the best silks at the criminal bar.
All right. Thank you, Walter.
Pleasure.
Mr. Clegg, you have my sympathy for the predicament in which you find yourself. I mean it. But you are largely responsible for Mr. Main's present position. And I must insist that you recognize that any further contact between us could be misconstrued to our mutual disadvantage.
Yes. Oh, one other thing. Shannon's got some cockeyed notion he'll prove Gibbard did it by telling the jury his previous convictions. He can't do that, can he?
You don't need that sort of work.
I need that sort of money.
Why?
I spent 3 days before the committee, and God knows how many preparing it. Now there's a striking off order against me in last year's tax bill. I need money in the bank.
I'll see that Margaret does what she can. Now, what are your grounds of appeal?
Lack of evidence.
You tried that on the disciplinary committee and it didn't work.
Henry, there's no difference between me and Roy Wilson Gibbard. Unless both cases are proved beyond reasonable doubt, the verdict must be not guilty.
David, isn't it time you accepted the inevitable? You should have admitted guilt. Then with a good plea and mitigation, you would have got away with a 3-year suspension.
My second ground of appeal is even better. One of the oldest principles of English law is that a man's previous convictions cannot be used against him.
There are exceptions to that rule.
But not in my case. And yet the committee knew all about my previous convictions.
You're not a criminal.
I have a professional record.
What are you talking about?
5 years ago?
Oh, that thing with Findon.
Mm-hmm. My articled clerk put in a false discretion statement to the divorce court. I had to take the rap for that. I pleaded guilty to conduct unbefitting a solicitor and was reprimanded.
The committee doesn't look at a man's record before verdict.
After sentence, I asked the committee if any of them knew of my previous when the case began. 2 of them nodded before the chairman ruled my question out of order.
I'm not surprised. All reprimands are published in the Gazette and everybody reads them. Yours in particular.
Could you reach an impartial verdict if you knew the man in the dock had done it before?
I'm a recorder. And when I try criminal cases, I'm allowed to see the prisoner's previous conviction.
They're available to you, but do you in fact look at them?
Well, I prefer not to. But then perhaps I'm overcautious.
The disciplinary committee is both judge and jury. Now tell me I'm going to lose my appeal.
If you take on this criminal Gibbard, and they bring in his previous convictions, you'll probably get him off on a technicality. Mm-hmm. But you were tried by lawyers, and your appeal will be heard by more lawyers. The Lord Chief Justice and 2 other High Court judges. And you won't win that one either.
But where the hell is Maine? I'm not paying $2.5 grand for the office girl.
Mr. Gibbard, you have just been to Magistrates' Court for committal, a pure formality that I was quite capable of handling.
Yeah, I paid for Maine.
Who has other problems as well as yours. When it's necessary, he'll be here. And by the way, I'm a lawyer.
Yeah, the social conscience one, I remember.
Now, I understand you want Mr. Hugh Neville, QC.
Well, Maine's the best solicitor, Neville's the best barrister.
I've been on to his clerk, and he's agreed to a preliminary conference this morning to make up his mind whether he'll take the case. Meanwhile, I want to run through your list of previous convictions to make sure that I've got them all.
Thank you.
Good morning, Mr. Neville.
Good morning, Miss Castleton. Gibbard.
Mr. Neville?
Sit down, please do. Take no notice of me. I just want to sit and listen a bit, you know, and may pop in a question or 2 later on. Please, carry on, Miss
Yes,
Castleton.
right. Now, your first conviction was at 16, shoplifting.
I was a juvenile.
2 years probation. Warehouse breaking a year later. Borstal at 19, the conviction for murder.
Reduced on appeal to manslaughter. Self-defence. I got 3 years for that.
You were lucky.
At 22, you began burglary. For your first offence, you got 2 years. 3 similar jobs taken into account.
I had a solicitor age 70 and a barrister with a new wig.
Your last conviction was at the age of 25, also burglary. You put the house owner in hospital for a month. And for that, you got 5 years.
Lots of porridge, luck of the draw.
2 similar offences taken into account.
But what's all this got to do with whether I'm guilty?
Well, we'd like to know what sort of man we're dealing with. What's the evidence against him?
Yes, he was picked out by a neighbour on an identification parade.
Yeah, but not in a magistrate's court just now.
No, that's right.
Well done.
And a police officer on foot patrol saw him a few streets away at about the right time.
Oh, the fuzz'll say anything.
They don't usually commit perjury.
Unfortunately, you made a statement to the police. Just because it's my M.O. doesn't prove that I did it.
I never make statements to the fuzz. Shannon's made up that verbal, and it's beautiful. If I've got an M.O., that makes me an ex-con, right? And that's Shannon's way of putting the boot in with the jury.
All right, so they're lying. But it's still your M.O.
Oh, come on.
Time of day, afternoon. Quiet suburban street, cul-de-sac with a climbable fence leading to a getaway car parked for emergencies.
Oh, no, 6
And now
blokes.
access. Pane of glass carefully removed with a diamond head cutter. And only small jewellery taken that would fit into a briefcase now.
Well, that is a fairly accurate description of the 3 crimes you went inside for last time.
Oh, you're not going to fall for it too. I've done it before. I must have done it again.
What other explanation?
I didn't do it!
Well, that's not a defence, that's a protest. And if you didn't do it, who did?
No comment.
Well, your MO was used. Chances are it's somebody you know. Well, with a grudge.
Pretty serious grudge.
Somebody could have set me up for this. But that's my business.
Well, if you know who it is, tell the police. They'll deal with him.
I'm no grass. And Shannon wouldn't listen. Look, I didn't do this job, and no one can prove that I did. Not without using my previous. Now, making sure the jury doesn't hear my past record is a legal job. All right, it's a tough one, but that's why I'm paying top whack for Mr. Main and you, Mr. Neville. Because even I know that when the jury hears a man's previous, he hasn't got a prayer.
Mrs. Belbin, I'm sorry I'm late. I do hope Mr. Main told you that I would be conducting the interview.
Oh, I used to work in Mr. Main's house. He wants a secretary. I think he should see me.
Yes, normally he would, but he says he knows you too well.
Isn't that an advantage?
He says he's prejudiced. He wants an independent interview, searching and tough.
As you wish.
Now then, Mr. Main says that you're efficient and self-effacing. My father's met you. He remembers you as shy and potentially a good wife and mother.
How is Mr. Castleton? I liked him very much.
Yes, he's very well, thank you. And the first Mrs. Main says that you were good with children and a pleasure to have about the house.
That was 5 years ago. I looked after Mrs. Main's children while I was learning English.
These are very interesting facts, but, well, they don't really add up to the qualifications needed to be secretary to an English lawyer, do they?
When I left Mr. Main, I spent a year at Secretarial College. I then went to work for my father. He is a commercial lawyer in Oslo.
Yes, we do business with him. You're Norwegian?
No, British. By marriage.
Yes.
I have 120 words a minute shorthand, 70 typing.
Yes, that's very good speeds.
In English, French, German, and Norwegian.
Do you have a notebook with you?
Of course.
Well, I'd like to give you a shorthand test. In English.
Certainly.
Where design, system, criminal intent, or guilty knowledge on the part of the prisoner is to be proved, or the defense of accident or the like is to be met, the prosecution may give in evidence other instances of the prisoner having committed offences similar to that for which he is under trial.
Inga, my dear, this is good news. David told me you were coming.
Father, I'm in the middle of giving Mrs. Belvin a shorthand test.
A waste of time? She's brilliant at everything. Mr. Main has no idea how to treat a secretary, so you mustn't let him bully you.
No, Mr. Castleton.
When will you start?
Sheriff and Mr. Neville, gin for me.
Thank you.
Easy on the tonic. Thank you.
Well, cheers.
Cheers. So, you'll take on Gibbard?
I'm earning too much, thanks to chaps like him. The Chancellor's after me again to become a High Court judge.
I thought that was supposed to be classified information.
Well, call it rumour. Still, I think I'd better accept it this time.
But you'll take on Gibbard first?
It'd be nice to go out on a victory.
Well, it may not be that easy.
So? So let's talk about your problems, David. They're a damn sight bigger and more important than some minor hoodlum who enjoys breaking heads.
Yes, fine, thank you.
Now, the disciplinary committee have struck you off and you've appealed.
Yes.
Right, so let your friends help. You know, an eminent barrister was prosecuted once.
Yes, I know who you mean.
Right. Everyone at the bar knew him and liked him and knew he was innocent. 11 QCs appeared to defend him. No fee, just as a token of respect. Well, I can't speak for 11, David, but I can promise one.
I don't believe in charity in the law. I like to pay for professional services.
So you can kick backsides if you don't agree with them?
Something like that.
Yeah. You were born awkward, David. Make it difficult for your friends to help you, the few friends you'll admit having.
I'll accept help and be grateful, but it's a different kind of help I want. I don't need an advocate. I'll do the job myself.
Ooh, you're mad.
Yes, I know that. I do need your help in drafting my grounds of appeal. Then I'll need a conference, all day possibly. I want you to kick my case through the back of my head if you can, so that when I get up in person in front of the Lord Chief Justice and two of his learned brothers...
Yeah, a condition. I'll put you on the rack privately, but if I break you, you'll let me do the job, represent you at your appeal.
What kind of an offer's that?
It's one you can't refuse. And it's not an offer, it's a challenge.
Good morning.
I didn't expect you to start so soon.
I need the money. At 11:30, the conveyancing department would like you to sit in on a meeting about the Phillips garage purchase.
Instant efficiency. I'll have to learn how you do it. Could be looking for work myself soon.
You're lunching Lord Arkwright. I booked at Stone's Chop House. I believe he likes the roast beef.
You're different.
And when I looked after your children, I stopped eating English chocolate.
You've more confidence.
I decided to get married, Mr. Maine. The better you look, the better choice you get. Most of it's out of a bottle anyway. And by the way, can I have Friday morning off?
You've only been in the job 5 minutes.
It's the hearing of my divorce. It won't happen again.
I believe you. All right.
Detective Inspector Shannon is coming at 10 this morning.
Please don't make appointments with policemen without consulting me.
It's not an appointment. On the off chance, he said. Yes?
Inspector Shannon for Mr. Maine.
Miss Castleton is out seeing Gibbard.
All right.
I'll come out. This way, please. Mr. Maine has a very tight schedule this morning, but he can see you for a few moments.
Good morning, sir.
Inspector?
I'm required to serve on you notice of additional evidence.
What evidence?
It's the latest medical report on Mrs. Elizabeth Martin, your client's victim. She'll live, just.
Well, that's a relief. Whoever did
Your
this...
client did it. Shall I show you what sort of merchant you're defending? Mrs. Elizabeth Martin taken on holiday last year. Mrs. Martin taken in hospital 3 days after she'd received the gentle ministrations of Roy Wilson Gibbard. She'll need 10 operations under general anaesthetic for plastic surgery. The vision in the left eye is permanently impaired. The state of shock is something else. Oh, in 5 or 6 years, she should be able to manage without a full-time nurse. Look, Gibbard's a pro. He knows the law. He studies how we operate, and he breaks the rules carefully. The law he knows backwards is the one which says that nobody goes to prison without witnesses. If anybody's liable to identify him, they get a little mayhem on the memory box.
You don't have to tell me the man who did this is an animal. You do have to persuade a jury that man was Gibbard. This is merely prejudice, an attempt to create bias against my client, and it doesn't work.
Look, I don't blame you taking on chum here. I know you've got problems. All I'm saying is you don't have to bust a gut. Let the law take its course, and society will have one more cowboy out of the way for a few years. Now, there's a book at the yard. It's a black book, full of lawyers. Approach these men with extreme caution at all times. They can be dangerous. You know, you had a good reputation with us. Tough, fight it all the way, but by the book. But since that breathalyzer caper at Shelborough, I've had instructions. You're in that black book.
Mr. Shannon, I'm told you hate violence. Good. Fine. Violence is against the law. But you don't stop it by breaking the law yourself. Or trying to intimidate me. You've just tried both. Don't. Not with me. You'll lose. You were told I was busy.
Members of the jury, the defense is about to raise a point of law which it is my responsibility alone to decide. I will now ask you to retire while I listen to Mr. Neville's submission.
Margaret?
Father?
I'm just on my way back to Leeds. How's the Gibbard case?
I've just been on the phone to David. He wants to know the moment they got to the argument about previous convictions. The judge has just cleared the court. Jury are leaving now.
Who's the judge?
Fairbank.
Oh, dear.
Yeah, he's a real hardliner. Neville's not too hopeful.
Why call David? I mean, he's got the best counsel in the land, and you're not without experience.
Father, you very nearly paid me a compliment.
I mean it.
Thank you.
Look, I've just come from the Law Society. David's appeal comes up tomorrow, and some members give him a good chance, providing he's done his homework.
But he's been busy with clients in the office all day.
When will the man get his priorities right? Look, don't let him get involved here. Now, make him understand that you and Neville are quite competent to handle a straightforward point of law. Send him home with the appeal file and tell him to take the phone off the hook.
I'll do that.
Get that lot typed up right away, leave it on the desk.
And you were going to dictate notes for your appeal. You said put aside the whole afternoon.
If the judge lets in previous convictions, Gibbard's had it.
Your appeal is more important than just another case.
If this goes wrong, a man may serve 15 years for something he didn't do.
If you lose your appeal, how long are you struck off for?
My lord, the prosecution say that the reason they wish the jury to see my client's previous convictions is to show system, that my client always uses particular methods, which he has used in the past. But in my submission, the truth is that the prosecution case is so weak, it will only succeed if overwhelming prejudice is created in the jury's mind.
Evidence of system is admissible under English law. Prejudice is merely incidental.
Yes, indeed, my lord, but in the case of Harris and the Director of Public Prosecutions, 1952, it was clearly stated, even where such evidence is strictly admissible, the judge has a discretion to exclude it if its prejudicial effect to the prisoner would be out of all proportion to its evidential value.
The discretion is mine, Mr. Neville, not yours. You say the similarity between the methods used by your client on previous occasions and by the criminal this time is coincidence.
Yes, my lord.
It is to meet just such a defense that previous convictions are allowed in evidence.
Yes, but in my submission it would be impossible for any jury to hear my client's record and find him not guilty.
Your client's previous convictions are hardly my fault.
But he is entitled to a fair trial on the evidence, my lord. If you admit his antecedents, a fair trial becomes impossible.
I am against you on this point. I accept the prosecution's view that his previous convictions are part of the evidence.
Get it adjourned. David's on his way.
May I ask for a short adjournment, my lord? Take fresh instructions.
Let me know when you want me back.
All stand, please.
Oh, the jury is my record. I'm dead meat.
You underestimate my forensic ability, Gibbard. There's little specific evidence against you. There's your own verbal to the inspector.
Fairy stories.
And a police officer on foot patrol says he saw you a few streets away
Says he
at
saw.
about the right time. But on the other hand, Mrs. Martin, the victim, has no memory of the events. None of the stolen goods were found in your possession. There's no fingerprint evidence. And that next-door neighbour who picked you out of the ID parade failed to identify you in the magistrate's court. No, I think there's a good chance before this jury.
With this judge doing the summing up?
If you're convicted, Mr. Gibbard, we can appeal on your previous.
No.
What?
The appeal court can overrule the judge on a point of law and he goes free.
You're forgetting the proviso to the Criminal Appeal Act. If the Court of Appeal, looking at the case as a whole, decides there's been no miscarriage of justice, the conviction stands, point of law or no point of law. The proviso was tailor-made for Roy Wilson Gibbard.
Well, what would you do?
Take no further part in the trial. No cross-examination, no defense, no closing speech to the jury.
What, just drop hands, give up?
That guarantees you'll be convicted.
Right, but it'll stop the Court of Appeal applying the proviso.
Oh, hang about. Look, I'm not getting any of this.
Right. Letting the jury hear previous convictions is a point of law decided by the judge. Now, if he's wrong, and in this case he is, he can be overruled by the Court of Appeal.
Yeah, right, I got that.
But if the Court of Appeal thinks the judge's decision didn't produce any injustice, that the jury would have found you guilty anyway, the appeal is thrown out.
So we fight like hell to win here?
No, you make your stand on the point of law. From now on, no defense, so that when we win on the point of law, they can't apply the proviso.
Why not?
Well, you make miscarriage of justice certain by refusing to defend yourself, you see. It's a hell of a risk, David.
You're gambling everything on one small point of law being right.
Mm-hmm. Well, my advice is that we fight like hell here. I can always argue the miscarriage of justice proviso on appeal if I have to.
Yes, I agree with that.
Up to you, Gibbard.
Oh. I'd like a word with Mr. Main.
Right. Thank you.
Clegg says you're still the best.
Mr. Clegg to you.
But the word in here is that you're in so much trouble you can't even see straight, let alone think.
It's your decision. You've heard the arguments.
It's just a legal game to you, isn't it? Make up your own bloody mind, Gibbard. Well, I'll tell you something, Mr. Maine, sir. I'm 33, and if I go down, we're talking about the best years of a man's life. Now, for $2.5 grand, I'm entitled to commitment. Someone to believe in what they're doing. So stop warbling and start operating. What's up with you? Don't you care?
I have a daughter, aged 10. The reason she's forbidden to open the front door after dark is because somebody like you might be leaning on the bell. If I were a judge up there and the jury found you guilty, I'd make sure you didn't come out of prison till you were senile. And that's me, David Maine, human being, acting like one.
You are my
Yes,
lawyer.
and that's what I'm working at now, so don't expect violins as well. You're paying for my brain to use the law in your defense. Until they prove you did it, the law says you're as innocent of that piece of mayhem on Mrs. Martin as my daughter. It's called rule of law. Rule of law depends on people like me defending people like you on charges like this so that the charges only stick where they belong. Without rule of law, heavies like Shannon would use hunch instead of evidence and a firing squad in place of a jury. Without rule of law, the Chief Justice is hijacked from his own courtroom by army hooligans and never seen again. And that's not the Yukon or Hitler's Germany. That's February 1973, Uganda. And ignore my advice if you want to, that's your privilege. If you think I'm past it, sack me, that's another of your rights. But if you want me to bleed for you, you've joined the wrong social club.
Yeah. All right, Mr. Maine. Tell me again.
This is what'll happen. The judge will let in your previous, the jury will find you guilty, you'll be sentenced. Don't worry. It's like taking a bath. After a while, you get out, on appeal.
Roy Wilson Gibbard. The jury have heard a prosecution case which included evidence of similar methods you have used on other crimes. They found you guilty of yet another serious charge of robbery, a wanton attack on a defenseless woman. I entirely agree with their verdict. The fact that you've made no attempt to defend yourself is your affair. It is now my function to sentence you. And in doing so, I take into full account your criminal convictions of the past, from which it is clear that society will not be safe so long as you are at liberty. You will go to prison for 12 years.
If that's burglars, we've got plenty.
Mr. Maine, I'm sorry. I didn't know there was anyone here. I left some shopping.
I thought you'd gone home.
I've been out to dinner. It's 11:30.
I was reading for tomorrow, the disciplinary appeal. I must have fallen asleep.
You haven't changed. 25 hours a day, 8 days a week.
Life doesn't stop for sleep, nor do people's problems.
I'll do that. Coffee or tea?
I seem to remember you make coffee taste like it smells roasting. Rare talent. What happened to your escort? You said you'd been to dinner.
With my solicitors.
Jonathan Breeden.
How did you know?
Saw a letter on your typewriter.
He wanted to give me my degree absolute, in person, and to go to bed with me. He said he couldn't suggest it before the divorce came through because I was his client, and that would have been professional misconduct.
Breeden the groper, we called him at law school. Now he does the legal night shift. Round of London clubs till dawn, then a brief dialogue with a tape recorder telling his partners what business he touches.
He got me my divorce. He must be a good lawyer.
Not that good. Not if he doesn't know the carnal knowledge of a client hasn't been professional misconduct since 1946. Thank you. You've done it again.
Good.
Now have some yourself.
No.
Drink?
Perhaps some tonic. No gin.
No, you could drink that stuff neat.
Tell me about your divorce.
When I left you, I went home to Oslo. I took a secretarial course. Then I went to work for my father for a while. I then got a job working for the director of a timber company for pin money. Ian came out to us for a year to learn the trade. 2 months later, we were married. At first, it was very good. We were very happy. Then we came to London.
Then what went wrong?
In Norway, he was a sort of a guest star. Different. Everyone wanted to know about England, what he thought about the common market. It was very flattering. Then England. The routine. Cobham. Ian traveling to the city. He wasn't a novelty anymore. Just another commuter from the gin and tonic belt. The neighbors in the golf club thought I was a jumped-up au pair girl who'd married above her junction. Is that the phrase? Instead of the expensively educated daughter of one of Scandinavia's best lawyers. He began seeing more and more of his friends and less of me. Home became a hotel. One night he didn't come in at all. That happened a few more times before I admitted defeat. I don't blame Ian. He's just very English. He doesn't like foreigners unless he's abroad.
Maybe he doesn't like perfection. Most men don't.
What do you mean?
Everything you do is a little too calculated, perfect. Dents a man's ego. He likes frailty. Selfishness, even. Something to forgive, protect.
Mr. Maine, I think you're smug. Superior.
No. The lawyer's disease. Assessment.
What happens tomorrow?
Oh, the Lord Chief Justice of England, 2 High Court judges, wigs and robes, fanfares and traditions, up there on the high bench. Litigants in person they put in the well of the court so that you can't see who you're talking to without breaking your neck.
You're used to appearing in court.
They're not there, and not in my own defense. I'm doing something very un-British. I have to tell those eggheads the referee was wrong.
This isn't a game.
Englishmen do unspeakable things in the midday sun, but they never question the referee's decision. And that's how it'll appear to them. So the first job is to make them even listen.
You make it sound impossible.
Perhaps. Stop sounding like my senior partner and drink your tonic water.
David. Drop by to wish you luck.
Thank you. Lord Chief is presiding, I hear, with Otis and Fairburn.
Well, Otis is right. He'll give you a chance, but it's a pity it's Fairburn's turn to sit.
Yeah.
He's already decided your point of law in the Gibbard case.
Why doesn't he disqualify himself? Conflict of interest.
Different case, different facts.
Well, David's a solicitor in one case, appellant in the other. There's no conflict.
So, we concentrate on the Lord Chief and Otis.
Well, the Lord Chief invented the establishment. He'll back the disciplinary committee every inch of the way. He'll have to go some to get his vote.
David, there's still time to let Mr. Neville act for you. Now, in my opinion, you lost last time because you insisted on being your own advocate.
A lawyer who acts for
As a
himself.
fool for a client. Platitudes for the incompetent.
Or the oversensitive. Oh, come on, give me 2 minutes to robe, I'll take you like a shot.
Anything I can do, Mr. Maine?
Mr. Clegg.
Anything at all? I was inquiring about giving evidence, Mr. Castleton, which I was prevented from doing in the disciplinary committee, both by Mr. Maine and the Law Society.
What evidence?
That Mr. Maine knew nothing of my theft or forgery until after it had happened, and then it was too late for him to do anything about it.
But Mr. Maine isn't accused of helping you steal Walter, but of condoning it, adopting it.
He didn't do that either.
If that statement is made on oath to this court, you'll go free, David.
Walter wants to commit perjury. Would you call him to give evidence?
Well, as an officer of the court, I can't put forward a witness I know will tell lies.
He's serving 1 year suspended on my account. He's not adding another 5 actual to that, even if the perjury is well meant.
Oh, here we are.
Go on. Thanks for trying, Walter.
All stand, please. In the matter of a solicitor, David Maine, against the Law Society.
The only evidence given by the Law Society was that my clerk, Walter Clegg, had been convicted of stealing a blood sample.
And that when asked to give an explanation of that conviction, you said no comment.
He pleaded guilty, my lord. Doesn't that speak for itself?
He was your employee. The blood sample was taken from the man accused of killing your wife and son. Do you deny the right of the Law Society to ask you for an explanation?
No, my lord. What I say is that the disciplinary committee cannot assume from my refusal to give one that I have committed misconduct.
How do you know they did make that assumption?
Because there was no reliable evidence of misconduct.
You signed the check to pay for the analysis of the stolen blood sample? That's evidence of your conduct?
Every solicitor signs checks for small amounts without knowledge of the background.
The committee was entitled to accept that evidence at face value.
The Law Society had to prove a case against me beyond reasonable doubt. That piece of evidence was riddled with doubt. And Clegg's conviction was no evidence against me, only against him.
Are you saying that the right to silence, such as a prisoner has in a criminal trial, extends to a solicitor when the Law Society asks him for an explanation?
My lord, if a man is seen in the vicinity of a crime and offers no explanation for his presence, his silence alone is not enough to convict him. There must be some other positive evidence. In my case, I was in the vicinity of Clegg's crime. That's all they could prove. Everything else was assumption, not evidence.
I see the point.
I'm sorry. I can make no appointments for Mr. Maine at the moment. Yes, Lord Arkwright, I realize he knows you well, but those are Mr. Maine's instructions. No, I don't know when he'll be back in the office, but I'll be happy to give him a message as soon as he...
When the committee heard the case against me, a majority of the members knew of my previous conviction.
Hardly conviction. 5 years earlier, you were reprimanded for a minor misdemeanor by your articled clerk.
I would not describe the deliberate deception of Her Majesty's Divorce Court as a minor misdemeanor, my lord.
Nor would I.
Well, you cannot compare it with a criminal conviction.
Well, why not, my lord? Its effect is the same. Prejudice. If you've done it before, you've probably done it again.
Anyway, what you say is that because 2 out of 3 members of the committee knew, from publicity at the time, that you'd been charged with misconduct previously and reprimanded, a fair trial was impossible?
Because they didn't declare their knowledge and so give me a chance to deal with it.
Members of a jury may remember reading of a prisoner's previous convictions. That's a similar situation.
Would it be proper, my lord, for any juryman to serve on a case where he knew the prisoner or his record?
No.
A lay jury may not realize the potential prejudice. The disciplinary committee is all lawyers. They must have known.
The Law Society is supposed to make sure that every lawyer knows when a solicitor has committed misconduct. Now, if your argument's right, no solicitor could be tried a second time, whatever he did wrong. You couldn't form an unprejudiced committee.
I'm not dealing in generalities, my lord, but with one specific case. If at a criminal trial it came out that a majority of the jury knew of the prisoner's previous convictions, he'd get off on appeal.
Possibly. But a disciplinary committee consisting exclusively of lawyers has the knowledge and experience to put prejudice out of its mind.
My lord, a judge is allowed to look at a prisoner's record before the trial begins, yet many refuse to do so because they won't run the risk of being prejudiced.
A nice point, Mr. May.
It's never bothered me.
This is the classic proof of one of the oldest legal principles. That justice must not only be done, it must be seen to be done. I am an officer of the Supreme Court. Will the law deny to me the protection it demands for a common criminal? Dust off the vintage wines, import the caviar. One last extravagance on the office expense account.
It's not very flattering.
Put on your Norwegian accent in your maiden name, I'll tell the taxman you're a foreign client with demurrage problems.
Can't you think of anything without giving it a legal meaning?
No. Cheers.
What are your chances?
Well, Hugh Neville's taken a tenner from every member of his chambers that I'll win.
Why so depressed?
Because I'm guilty, even if I win. Other people's guilt doesn't bother me. My own does. Lawyer, defend thyself.
You're talking about moral guilt, not the law.
Yes.
But the people you tried to stop, the driver, the analyst, they are much more guilty.
For the first time, I take no pride in the way I'm practicing my profession.
Oh, these are only ideas. I'm more interested in people. People like you and the people who come to you for help. You don't see them when they first arrive in your office. Frightened, terrified, all with big troubles. Potential suicides. The next time I see them is coming out of your room.
Oh, the troubles are left on my desk.
They have transferred a crushing worry to someone else. They have their confidence back. Some of them almost arrogant, as if they didn't need a lawyer in the first place. It may be because I'm new at the job, but they look like small miracles to me. They can't take away your license. People like you are needed. You're necessary.
I do not agree with my learned brother. I am not persuaded by Mr. Maine's arguments. I would dismiss the appeal.
This is an appeal by Solicitor David Maine against the findings and order of the Solicitors' Disciplinary Committee that his name be struck off the roll of Solicitors of the Supreme Court. My brother judges are divided in their conclusions, so that I have, so to speak, the casting vote. The Law Society has a duty, on behalf of the public, to ensure proper standards by solicitors. It carries out that duty by seeking explanations where circumstances call for them. If no explanation is given, I think it is open to the disciplinary committee to find misconduct proved, provided there is some evidence linking the solicitor with the complaint. In this case, there is evidence, a check bearing Mr. Maine's signature. Now, if he did not know what that check was for, he could have said so on oath. He chose not to do so. As to the second ground, knowledge of a previous reprimand, that is more difficult. One of my brothers would allow the appeal on that point. But if Mr. Maine is right, a solicitor could commit subsequent professional offense with impunity. He could not be tried a second time. Now that cannot be the law. Finally, I come to penalty. I think solicitors must be the best judges of who is entitled to practice their profession. In the absence of any indication that the committee was wrong in principle, and taking every factor into account, I would not interfere with the order that the name of the appellant David Main be struck off the roll of solicitors of the Supreme Court. The appeal is dismissed with costs against the appellant.
All stand, please.
Nine, 10 out. Finish. I lost.
No. House of Lords, if necessary.
I agree to that.
No.
Look, you convinced one High Court judge, and the Lord Chief was struggling. You can do it again, David. You can run this all the way to the House of Lords.
I know what I did. I knew the risk. I knew the price. I decided a long time ago that if I couldn't persuade the Lord Chief...
No, sleep on it, David. Think again.
Thanks, you. Thanks for everything. Watch out on Gibbard. I won't be around on that one now. Henry, the great thing about our partnership was trust. I broke that trust. Now we all pay. Goodbye, Henry. Goodbye, Margaret. Peter Findon will be here at 11 o'clock tomorrow to take over my practice at the direction of the Law Society. I'll be in early to pick up my things. Well, me and Harrod's.
I presume you'll introduce him to members of staff?
You can do that. I'll be gone. I've said my goodbyes, paid all the debts I can find.
But there are things he'll need to know.
Every urgent file is up to date with a note of the next step pinned to the cover. Inside is a biography of the client with a rundown on character and, where appropriate, previous convictions. Provided he can read.
Let me come with you. You'll need someone to do the typing.
Stay with Findon. He's a good solicitor. I trained him. Make him pay an extra $5 a week. You'll earn it. And wear a trouser suit for the office. Otherwise, you'll find him losing track of his dictation.
The case of Roy Wilson Gibbard is further complicated by the fact that once the submission of defense counsel, Mr. Neville, was overruled by the trial judge, the prisoner refused to defend himself. An unusual and hazardous step, requiring considerable confidence in one's knowledge and judgment of the law. But for this decision, we might well have felt that this was a case in which there was no miscarriage of justice, but that is speculation. As it is, we find that previous convictions should not have been introduced. They were not evidence which tended to prove the prisoner guilty of the charges. Having reached that conclusion, we have no alternative but to allow the appeal. Discharge the prisoner.
The upstanding.
Oh, that was close, Mr. Neville. Thanks. Thanks.
Cheers.
Thanks again, Mr. Main. And now I'll see about my sword of justice.
I'll give it up, Roy. You're getting too old to use muscle for personal reasons.
Just one more job. Strictly for pleasure. And me.
The one who set you up for this. You know it?
Oh, yeah.
Tell the police, unless you want to wind up doing the 12 years it's just cost you a fortune to dodge.
Well, be lucky.
Evening, Inspector.
Usual, please. Same again for these gentlemen. If that's the way I had to earn my bread, I'd rather starve.
We may have to. You've lost before. What's the beef?
How the hell did Gibbard get off when you didn't?
He's just a citizen. I was a solicitor as well. Because I'm trained to know better, they sharpen the rules. Chop.
Cheers. Cheers. I won't pretend to be sorry for you. At least you won't be around to spring any more cosh artists like Gibbard.
I didn't spring him, the law did, and he didn't do it.
Who cares?
I do, for one.
He's done it a dozen times before. He'll do it a dozen times again and get away with it. Thanks to people like you.
No one can stop me working for you, now.
There's only one problem, Walter. What do we work at?